All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience à la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning, everyone. Court officer, please call the case.
Good morning, Mr. President, Your Honors. Situation in the Central African Republic 2 in the case of the prosecutor versus Alfred Yekatom and Patrice Edouard Ngai ssona, case reference ICC 0114-0118, and for the record, we are in open session.
Thank you very much. I ask for the appearance of the parties. Mr. van der Poel for the prosecution first.
Good morning, Mr. President, Your Honors. Good morning, everyone. Today, the prosecution is represented by Olivia Straven, Lucio Garcia, Yassine Mosfa, Leila Haxius, and Sylvie Yekatom, and myself. Good morning again.
Thank you. And for the victims of the other crimes, Ms. Masida.
Good morning, Mr. President, Your Honors. For the victims of the other crimes appearing today, Ms. Elizabeth Rabesandatana, Mr. Orcholona Ransetseng, Mr. Innocent Poko, Mr. Enrique Carnero Royo, Ms. Ejim Kim, Mr. Alexis Larivière, Ms. Eveline Ombeni, and myself, Paulina Masida.
Thank you. Mr. Seprun.
Good morning, Your Honors. The composition of the team representing the formal child soldiers is the same as yesterday. Thank you.
Thank you. I turn to the defense team of Mr. Yekatom, Ms. Dimitri.
Good morning, Mr. President. Good morning, Your Honors. Good morning, everyone. Mr. Yekatom is present in the courtroom, represented today by Ms. Sarah Bafadel, Ms. Anta Guissé, Ms. Sabrine Beysat, Mr. Florent Pages-Granier, Mr. Guillaume Suzuki, and myself, Mylène Dimitri.
Thank you. And finally, for the defense team of Mr. Ngai ssona, Mr. Knops.
Good morning, Mr. President, Your Honors. Good morning, everyone in the courtroom. Our team today is virtually the whole team. That's to say, Ms. Barbara Spazzula in the first row, and on my right side, Espina Eleftherio. First row on the left side, Lorian van der Leer, Nina Dijk, Mrs. Knops Hamburger. Second row, Ms. Madame Proux, Melissa Beaulieu, Chiara Giudici, and Sarah Pedroso, Michael Rouse, and Lena Gidi, and Mr. Ngai ssona in the third row.
Thank you, Mr. Knops. And of course, you know that I will give you the floor for the closing arguments of the defense of Mr. Ngai ssona.
Good morning, Mr. President, Your Honors. Good morning. On behalf of the defense team, Mr. Ngai ssona, we present today to the court our oral submissions, and the first slide you will see now presents our outline of today's presentation. You'll see in the first and second session the topics we will deal with. The introduction and the second topic will be dealt with by myself. Ms. Eleftherio will deal with the third topic on the contamination witnesses, after which I will go into the alleged contribution of Mr. Ngai ssona. Then Ms. Giudici will deal with the Facebook regarding 5 December, and Ms. Beaulieu, the common purpose issue. And the third session will be dealt with by Ms. Marilyn Proux, and you'll find the topics on the third session here in the slide as well. And I will close hopefully with 5 minutes at the end of the hearing, Mr. President, if time permits. Your Honors, today is 12th December 2024. Exactly 6 years ago, Mr. Ngai ssona was arrested in Paris, exactly on the same day, 12 December 2018. Yesterday, Mr. President, also marked the 5-year anniversary of the confirmation of charges decision. In that decision, Your Honors, the Chamber noted that key findings regarding Mr. Ngai-ssona's alleged criminal responsibility were based on second-hand information and inferences, and that Your Honors can read in paragraph 102 of that decision. Pre-trial Chamber 2, back 5 years ago, foreshadowed that the prosecution might not be able to secure a conviction on this type of evidence. The Chamber said, and I quote, "The evidentiary threshold applicable to this stage of proceedings requires substantial grounds to believe, as opposed to the more exacting threshold of the trial stage." End of quote. Mr. President, 5 years later, today, the prosecution has not met this exact threshold. It continued to rely on the same type of evidence as if the trial during the last 5 years never happened. Prosecution said on Monday, Mr. President, Your Honors, that Mr. Ngai-ssona had a choice. He had a choice to step back and not intervene. We say today to the Chamber and to the prosecution had also a choice. It could have accepted that it would never meet its burden at trial. Instead, it chose willful blindness. Willful blindness, which resulted also in a devastating effect on the life of a person who is not guilty of the charges. Not only on his life, but the life of his wife, his 9 children, and his 9 grandchildren, among which one of the children, a child from 12 years old. Mr. President, during our presentation, we will explain what we mean with the expression willful blindness. The prosecution case, that's the second topic of our outline, is premised on several illusions and even phantoms it has created throughout the trial in order to close its eyes for the reality which ensued after the confirmation of charges decision. Illusions and phantoms such as an inner circle, an organizational policy, a criminal policy, and the concept of a single-minded, power-seeking person, namely Mr. Ngai-ssona. But the prosecution was well aware that it had to make this phantom alive before this court. And to do so, it had to distort the evidence which ensued after the confirmation of charges hearing. It had necessary to turn a blind eye to the reality of the evidence. To pursue this phantom, Mr. President, Your Honors, before this chamber, the prosecution indeed has systematically distorted the evidence to fit its case. In this presentation, we're going to show the court how the prosecution did so and how it tried to mislead the chamber. I have 2 striking examples, Mr. President, Your Honors, to begin with. The first example you can already find in our defense response of the 21st July 2023 in paragraph 8. It was our response to the 7th bar table motion of the prosecution. Now, what happened there, Mr. President, in that stage of the proceedings? The prosecution inadvertently shared two internal comments with the defense, which were ultimately removed from the filing. And we'll now show you, and it's not meant for the public, but just to show to the court and the parties and participants in this chamber. We'll show you a first screenshot on this slide, slide number 4. You see a Facebook message between Levi Yakite and Danboy Fanny with the additional comment of the prosecution. I cite, "It could go against the meetings in Cameroon pre-July 2013, therefore not including it in the bar table." That is the comment of the Office of the Prosecution, a so-called truth-seeking organization. The second example, item 2, is a Facebook message between Mr. Levi Yakite again and Kokata Dobi Stan, with again a personal comment of the prosecution saying, however, in this conversation Yakite denies having distributed weapons to Kokora. Worth putting it in? Question mark. No, it was apparently not worth putting in for the OTP ultimately because it would go against the theory. Mr. President, such an approach goes against the legal and ethical obligation of a prosecutor to seek for the truth. And this is just one of the many examples you find in our response to the 7th bar table motion. Your Honors, the second example happened really before your own eyes. Your very own eyes last Monday. You've heard the prosecution saying on Monday that Mr. ssona was involved with Kokora. That is their theory. It was the theory from the beginning. The prosecution yet only selected one sentence of a speech of Mr. ssona of 6 January 2013, where he said that he consulted Kokora. However, the prosecution failed to mention that Mr. ssona, in this very speech of the 6th January 2013, called upon all members of the civil society, not only Kokora. And you'll see it on this slide, left top, the quotation of the prosecutor, and the right side of the slide, you see the full context of the speech of Mr. ssona of the 6th January 2013. And you see, Mr. President, Your Honors, in this speech of the 6th January 2013, Mr. ssona is not calling only upon all members of the civil society, including the political opposition, but he also calls upon to reject civil war. He calls for the return of peace in the car. And you will see in the transcript him saying, "Nous rejetons fermement la guerre civile. Nous refusons avec fermeté la division. Nous voulons que notre patrie, la République de Centrafrique, reste une et indivisible. That is the real context of the speech of Mr. ssona. And Your Honors, to quote the words of Prosecution Counsel last Monday, there you have it. To use the words of Prosecution Counsel, there you have it in black and white. These were the words of Prosecution Counsel when he was referring to other speeches and alleged correspondence on this matter. There you have the black and white. No Kokora involvement. Il a discuté avec Kokora. No hate speech. Mr. President, Your Honours, there is more to say about willful blindness in this case. The prosecution willful blindness to have the phantoms, these illusions we started with this morning, come alive is visible throughout its whole brief. And it manifested, as Your Honours can see in the brief, through 7 contentious tendencies. And we will show them all 7, detected from the brief of the prosecution. The first contentious tendency to keep these illusions alive in this courtroom is the phenomenon of cherry-picking the evidence. This is the first prosecutorial mechanism to keep these phantoms alive. The prosecution has selected only the evidence that did fit its narrative, while discarding the evidence that didn't fit its narrative. This results in several gross misrepresentations of the evidence. In a number of cases, the prosecution only cited the prior recorded statements of witnesses to fit its narrative, while omitting to refer to live and direct testimony of both prosecution and defense witnesses. It is not only misleading, but it also contradicts the principle and the primacy of orality. I'll give you just one example with this first tendency, although many will follow in our presentations. At paragraph 112, footnote 214 of the prosecution brief, the prosecution argues that Mr. Ngai said that he realized that Mr. ssona had prior links with the military. Here you see that the prosecution relies only on Mr. Ngai's prior recorded statement, but entirely ignores, Mr. President, that the live oral testimony given by this witness was quite clear, namely that he never had the impression that Mr. ssona was involved in military activities. The second contentious tendency whereby the prosecution demonstrates willful blindness for the reality of this trial is the phenomenon of unsupported allegations. The court can observe in the brief of the prosecution that in a number of cases and throughout the whole brief, the prosecution made entirely unsupported allegations. In some cases, Mr. President, the prosecution was even willing to add content to the evidence, to several items of the evidence, without the content being actually there. For example, OTP brief, paragraph 121, footnote 231. The prosecution tries to make the court believe that messages from Mr. Mokom himself confirm that Mr. ssona was liaising with Maxime Mokom. Yet, a review of those messages, Mr. President, and this exchange in question, dated 13 January 2014, only indicates that Mr. Mokom had phone contacts with Le Vieux in Cameroon, with no mentioning of Mr. ssona. The same pattern can be observed regarding the CDRs. In assessing the CDR's evidence, Mr. President, the order should be particularly alert to the prosecution basis for attribution. Attribution to certain phone numbers to individuals. The prosecution's attribution should not be taken at face value by this chamber. For example, if you look at the phone number attributed in footnote 362 of the prosecution brief, as the number ending with 3464, and the reference in footnote 396, that's the number ending with 6297, the prosecution, as the court will see, does not present any supporting evidence for such attribution. Mr. President, the third contentious tendency the prosecution uses to disguise the absence of evidence is what we call evidentiary shortcuts and conceptual leaps. The prosecution has put the cart before the horse in this case, Mr. President. It attempts to fit the evidence into preconceived narratives by using evidentiary shortcuts and simplistic conceptual leaps. For example, the prosecution equates the anti-Balaka with a group it labels youth, suggesting that the term youth is some kind of monolithic entity. Prosecution brief para 16. We recall, Mr. President, and that's to be found also in the prosecution witness statements P2252 and P808, we recall that about half the car population can be labeled as youth. A court of law cannot rely in our submission on such sweeping generalizations which lack the rigor that one would expect from a prosecution service. Another example is of such a shortcut, Mr. President, Your Honors, is to be found in the prosecution brief para 149, which should support that Mr. ssona was aware, it says, of the anti-Balaka targeting the Muslim population. Yet, the OTP only relies on P2232's testimony that Mokom received reports after each attack and that Mr. ssona and Mokom were liaising, so that Mr. ssona must have been aware. That is clearly a conceptual leap the prosecution makes itself without any supporting evidence. The fourth contentious tendency the prosecution tries to introduce into the minds of this chamber. That's what we call reliance on evidence it knows to be false. Mr. President, despite the prosecution being fully aware that its evidence on essential key points was not reliable, it still refers in their closing brief to such evidence against all odds. The most striking, or one of the most striking examples of many, is the Facebook post of Froka Bangui, or Bangui Froka, claiming anti-Balaka fighters are outside Bangui in late November 2013, without addressing the prosecution the obvious misrepresentation of this image in para 234 of its brief, footnote 470. Your Honors know, and also the prosecution, that we, defense, alerted the Office of the Prosecution already in July 2023, that the pictures of fighters posted by Bangui Froka were not taken in Bangui. Were not taken in Bangui. Not even in the Central African Republic. But they reflected, Mr. President, pictures from 2010 till 2011, reflecting images of the post-electoral crisis in Côte d'Ivoire. And they were presented to this chamber again in the brief as if they were taken on the outskirts of Bangui in 2013 and depicting anti-Balaka fighters, Mr. President. Mr. President, the fact that the prosecution continues to turn a blind eye to this obvious fake news shows that they are willing to persuade this chamber with evidence which is distorted, which is fake evidence, in order, against all odds, to fit its narrative. The same can be said about the prosecution willing and readiness, Mr. President, to rely on witnesses who clearly provided false testimony before this chamber under oath, such as P801, P0306, and P0487, to cite just a few one. Now, the chamber might recall, just to give an example, about P801, that this individual came before the court saying that there was a meeting in the CAR embassy in April, May 2013, and during this meeting, Mr. President, that was his assertion, Mr. Bozizé received a call informing him that his mother's grave had been desecrated. However, the evidence which was provided to this chamber showed that the body of Bozizé's mother was exhumed only in August 2013, months after Bozizé and Oguere, the ambassador in Cameroon, left Cameroon. This is just one small example of many false testimonies given before this court, Mr. President. Now I go to the fifth tendency: over-reliance on hearsay and anonymous evidence. The prosecution, Mr. President, as the court undoubtedly has observed in its brief of the prosecution, excessively relies on anonymous hearsay, even to prove key allegations. For example, the brief of the OTP para 49-55 relies on this testimony of Mr. Demafoot as a source to make your court believe that Mr. Bozizé was involved in insurgency plans from Cameroon. We all know, we all saw that Demafoot turned out to be a deplorable source for anything alleging which happened from Cameroon. He wasn't there. And all the information he had came from so-called intelligence reports he relied on. Anonymous hearsay. Your Honors, did you see those intelligence reports? No. Where were the tapes, the Cameroonian tapes, Demafoot alleges to have seen, to have listened to in Cameroon? 10 years since the beginning of this case, since the beginning of the investigations, none of this ever materialized. The words of Demafoot were not supported by anything else but his words. The sixth contentious tendency of the prosecution to remedy the lack of evidence: excessive reliance on uncorroborated evidence of disputed witnesses, such as the three key ones for the prosecution, namely 2625, 1847, and 0801. And mind you, Mr. President, these two witnesses, this trio on which the prosecution repeatedly relies, should support the key allegations against Mr. ssona. Now let's have a look at those three gentlemen. It speaks, by the way, volumes that the prosecution's key three witnesses we just mentioned were at times the only sources for the allegations against Mr. Ngai. And if we look at their testimonies before this court, there is no other conclusion, Mr. President. These were fully untrustful, problematic, to say the least, contentious, and the testimony was highly problematic. They have each been, in the first place, been subjected of fierce litigation before this court itself. P0801 for his key role in tempering witnesses in the Bemba case. Credibility. P2625 for his wavering cooperation with the court. Lack of credibility. His testimony about the so-called secret archives, which were never produced, and what he said, dubiously destroyed. P1847 for the Chamber's finding of interference, which resulted in two completely different versions of his testimony without any indication for the Chamber as to which version could we reasonably rely on. Mr. President, Your Honors, these three so-called key witnesses have also, apart from their contentious nature, provided only fully uncorroborated allegations. Let us look at the three gentlemen. P081, meetings at Penn's villa in Bozé's presence, para 54 of the prosecution brief, footnote 93. Meeting in November in Yaoundé, paragraph 201, totally unsupported. P1847, his allegations that Bozé communicated with Penn through Bozé's aide de camp, Wapu Naba, totally unsupported, uncorroborated. And for P2625, Your Honors, you have heard a myriad of uncorroborated allegations. First, that Bozé rewarded Penn for his mobilization efforts with a ministerial appointment, para 39 of the brief of the prosecution. Second, that during meetings in Yaoundé with Bozé, everyone was in favor of regaining power at whatever costs. That Penn attended meetings in which Frocka's tactics in manipulating the non-Muslim populations were discussed, para 98 of the prosecution brief. That during Frocka meetings, Penn allegedly briefed the group on his interactions in the field with so-called his elements, and that on the status of ammunition and weapons, para 146 of the brief of the prosecution. All of this, Your Honors, relies on nothing more than the evidence of one witness, P2625. And okay. And Mr. President, Your Honors, if we refer to 2625, we are not even speaking about his lies to the court. Yeah, I apparently used the word pen, but that's Patrice Edouard Ngai, for the record. Sometimes in our team we have that abbreviation.
No
Sorry.
You know, some things don't have to be explained.
Thank you, Mr. President. Yeah. Well, not to speak about the lies of 2625. The example, Mr. President, which was more striking was that Mr. Poussou, Mr. Poussou's assertion that there was a second meeting in Hotel des Députés with Mr. Casson in the attendance of Mr. Cocotet was never confirmed by Cocotet in the first place. And secondly, we provided evidence to the Chamber that this was a full lie of proce, because we presented a document from Hôtel des Députés that Mr. proce never ever stayed in this hotel in the specific and the relevant time frame. You find it in our brief in footnote 1479 of our closing brief. A meeting, by the way, he never intimated during his meeting with the prosecution investigators. Now, lastly, Mr. President, if you look at these, at the dubious nature of these witnesses, these three key witnesses for the prosecution, combined with the incorporated statements and allegations of Mr. Garçonna's alleged responsibility, there can be no other reasonable conclusion for this chamber and our submission than to disregard this evidence, these allegations from these three people who were simply here for self-serving purposes. The last and seventh contention's tendency for the prosecution to close its eyes for the lack of evidence was the extensive use of Facebook evidence. Ms. Giudici will go into Facebook in more detail regarding the 5 December. But I simply observe with the court that in the vast majority of the users of Facebook, any lack of authentication or verification, as required also by the jurisprudence of the US federal courts, as the court might recall in my opening statement back in 2021, I already alerted to this jurisprudence. There is no verification provided by the prosecution of the authenticity and the veracity, the verification of the user by the so-called Facebook messengers. No expert was called by the prosecution. Individuals like Kefio, Gallo, Lamaka, Buragora, Nambobona extensively used their prosecution uses their Facebook accounts and messages without having ever called these people or went to those people to verify if these were indeed the users of Facebook and if their messages were authentic and the basis of their knowledge and messages. And this approach is even more defective since the witnesses who did testify before this chamber, Mr. President, on their Facebook exchanges all confirmed, without exception, that they circulated rumors and false information through Facebook. I'm thinking, for example, of P889, P2841, P2673, prosecution witnesses, all of them, D304679 and D304848. And your honors might recall, as a simple example, P841 saying before this court that Prince Lakutene would be willingly publish incorrect information, notably because he was part of a so-called virtual rebellion, and saying that certain towns had been attacked and taking responsibility for these attacks. Furthermore, the prosecution has misused the Facebook as an artificial instrument for cooperation, while in reality the underlying Facebook conversations do not corroborate the evidence at all, on which the prosecution intends to rely. As Justice Henderson held in the Blé-Goudet decision of 2019 in paragraph 47-49, corroboration, Mr. President, not only presupposes that two pieces of evidence independently confirm the same fact, but also require the respective items of evidence to have some intrinsic probative value in their own right. That was what Justice Henderson said in his decision in the Blé-Goudet case. And we have shown during our case that this principle has been violated by the prosecution. It's lacking here. And not only does the prosecution uses Facebook for cooperation, it also audaciously uses Facebook messages to corroborate testimonial evidence originating from the same Facebook source. A circular reasoning. That is not corroboration. You cannot say the witness is credible because he said so on Facebook. It's the same source. It's not corroboration. And that's what has been repeatedly done by the prosecution. A self-explanatory example is the prosecution reliance on Facebook message between P2841 and other interlocutors, generally Mr. Gallo, to corroborate the testimony of 2841. And you see, Mr. President, that the prosecution puts forward the general assertion that P2841 testimony is consistent with information provided in Facebook exchanges among individuals close to proce. That is their argument. But if you look closer at that message, those messages, you see that one of the two individuals discussing on Facebook is in fact always P2841 himself. Therefore, it's not surprising that during his testimony, this witness confirms having indeed had conversations and what he learned. This approach gives the appearance of corroboration while there is absolutely none. The evidence comes from the same source, namely Facebook, and should be considered not corroboration. You can find numerous examples of this deceptive approach in the OTP brief. For instance, paragraph 158, 168, 179, and 186. My final remark on the misrepresentation part is the following. Your Honors might remember that the defense in its opening statement on the 18th February 2021, page 21, lines 16-19, did set out the following prediction to the chamber, the very judges in this courtroom. I quote, Mr. President, the chamber can conclude from the remarks of the defense that when you will hear the prosecution case, you should be mindful that its case is indeed based on a selection of witnesses which are meant to fit into a narrative which is there to support the conviction. End of quote. 18 February 2021 was this said by the defense. Today, 12 December 2024, almost 4 years later, Your Honors, the court can conclude how accurate we were in our prediction. It all materialized what we said in our opening statement. And Mr. President, perhaps the most striking manifestation of the prosecution's motivation to obtain conviction at all costs is the incendiary campaign it waged against the defense team throughout the last 2 years. And I feel compelled also for my colleagues to say something about this. In the last 2 years, the prosecution has attempted to portray the defense team as guilty or at least complicit of witness interferences. The accusation of improper behavior by the defense has been raised during the examination with nearly every defense witness. Witnesses who sometimes had to endure very intimidating questioning, which continued this allegation in the written submissions of the prosecution. The prosecution has been relentlessly trying to influence the chamber, even when they attempted to obtain a rebuttal after the closure of the defense case, suggesting to the chamber that any testimonial evidence given in the favor of Mr. Ngai had to be obtained fraudulently through pressure and intimidation. Mr. President, I'm only going to say this to you today. Please bear in mind, when the prosecution has no evidence, he is looking for another way to distract the absence of evidence from the judges. And this is really what happened. Because there was no interference, this team operated according to the ethical rules which are applicable before this court. This was just a way to distract Your Honors from the prosecution's own failure to secure proper evidence and countering the defense narrative. That's the way it was. And that is fine in the court of law, as long as the judges see through this strategy. The relentless accusation, among which in the OTP filing 2666, of an, I quote, enterprise of interference and evidence fabrication, that was said about us, mind you, involving the defense, only shows the prosecution's unwavering drive in their willful blindness to secure conviction by all means necessary, even if it had to go to the expense of the truth. The topic Ms. Despina Eleftheriou now will delve into is closely connected with misrepresentation, and it has to do with the contamination of witnesses.
Thank you, Mr. Knops.
Good morning, Mr. President. Good morning, Your Honors, and good morning to everyone inside and outside of this courtroom. As counsel explained, I will be dealing with the part on the contaminating witness testimonies presented in this case. Your Honors, I appear before you today to lay bare a calculated plot against Mr. Ngai, a scheme that has compelled several prosecution witnesses to present false testimony before this court. This is yet another aspect of the unreliable evidence the prosecution presented in this case. Before I proceed, I would like to kindly ask Madam Court Officer that our next slide is only broadcasted to those in the courtroom. Thank you, Madam Court Officer. Your Honors, I will not use the names of those implicated in this scheme to remain in open session, as it is important that transparency prevails. The public, but most importantly, the citizens of the Central African Republic need to hear about the corruption that has infiltrated these proceedings and about the broader government-led effort to target Mr. Ngai. What you see before you, Your Honors, is a network of individuals, all interconnected, whose coordinated efforts have woven a web of lies. The relationships and interactions within this scheme are so intricate that we were compelled to create a diagram to illustrate it. Otherwise, it would have been nearly impossible to understand, let alone untangle it. This diagram showcases the depth of coordination and the deliberate efforts to falsely incriminate Mr. Ngai through a network of corruption and manipulation. What is the motive, you may ask? Your Honors, we sat in this courtroom for almost 4 years and heard witness after witness, be it a prosecution or a defense witness, testify that Mr. Ngai represented a serious political threat to those behind this plot. And the reason was his genuine popularity with the citizens of his country. Mr. Ngai earned that respect, not because of any alleged wrongdoing, as the prosecution will have you believe, but because he was a pillar in his community, known for his generosity to those in need and his outstanding work at the Football Federation. This reputation and his connection to the people is what made him a target in the eyes of those who wished to eliminate him from CAR's political scene. And what better way to do so than capitalize from his arrest and his transfer to the court, because in their minds, having Mr. Ngai in The Hague, where he, and I quote, allait faire 100 ou 200 ans, would stop him. The defense's investigations have uncovered a calculated and systematic plan to falsely incriminate Mr. Ngai. Witnesses were coached, they were bribed, and a smear campaign was orchestrated against him, with key prosecution witnesses being either complicit or directly linked to its perpetrators. Defense witnesses testified that none other than P2673 held meetings in his house and distributed payments to potential witnesses. Let's get back to the diagram and follow the money trail. Your Honors, the money started from those high-ranking individuals seen in the higher echelons of KAR's political elite. That money was funneled through intermediaries, as you can see in the middle of the diagram, only to end up in the hands of potential witnesses. Central African judges, lawyers, and prosecutors were present in those meetings, actively instructing people to create a false narrative. More meetings were held in locations I will not name in open session, but you've read in paragraph 44 of our closing brief, where pressure was exerted on individuals to falsely claim that Mr. Ngai led and financed the anti-Balaka. And of course, because how else are we going to make sure that he stays here for 100 or 200 years? We need to create those fabricated testimonies. And except for money, some of them, as you've seen in pages 2 to 3 of Annex A04 to our brief, also received undeserved positions in the government. This scheme has extended beyond coaching witnesses. It created an environment of fear and coercion. Potential witnesses were threatened, they lost their livelihood, and remained targeted by groups affiliated to the government, the same groups the registry periodically reports on. Despite these challenges, two courageous defense witnesses stood before this chamber and testified to these events, exposing the coordinated efforts to falsely incriminate Mr. Ngai. And what did the prosecution do? Absolutely nothing. This evidence was never challenged while the witnesses were testifying on the stand. It wasn't part of any rebuttal request. I mean, we all know what the rebuttal request was about. It didn't even form part of the closing statements the prosecution presented a couple of days ago. We were all here when D304914 offered his sources in the Presidential Guard and their phone numbers, only for the prosecution to move to the next topic in their cross-examination. And that can be found in the English corrected transcript number 303, page 64, lines 8 to 16. Is this surprising? Not at all. Because digging further into this, especially with the resources the prosecution has in its hands, would mean that a Pandora's box would open, risking to impeach the very witnesses the prosecution repeatedly cites in their closing brief. Just for reference, P1847 is cited 101 times, P1719 28 times, P2673 72 times, and Kokate, P0801 38 times. So instead of looking into this, the prosecution just swept it under the rug and called it a day, to borrow Maître Guisset's expression from yesterday. And that's because these are the witnesses whose alleged evidence, if we can ever call it as such, goes directly to the charges against Mr. Ngai. Which leads me to my next point, Your Honors. Some might say that this is a conspiracy theory created by the defense to impeach incriminating prosecution witnesses. Our written submissions may even read as a novel. But for Mr. Ngai, this is his reality. And speaking about novels, it was Ian Fleming who said that once is happenstance, twice is coincidence, 3 times is enemy action. And the examples in this case are far too many, almost as many as Mr. Ngai's political enemies. First example, all these high-ranking individuals who are pulling the strings of this plot, they all operate within President Ouattara's inner circle. They work for him. Some of them are related to him. All these people who are implicated in this plot are somehow linked to each other, be it through a personal or a professional relationship. Next example, the two people you see at the bottom left of our diagram, these two immediately benefited from Mr. Ngaisona's dismissal from the Football Federation. That's enough motive for anyone. And let's not forget P2673, the person who's right in the center of it and who received a great promotion just 2 months after he testified against Mr. Ngaisona. And lastly, let's focus on who these people are. Because Mr. Van der Puy on Monday said that the prosecution had 150 witnesses and 75 of those testified before this chamber. Yet, out of all these people, those implicated in this scheme are people who were easily corrupted and manipulated. These are not our words. These are the words of other prosecution witnesses who were cross-examined by the defense on these people. But of course, you won't find that in the prosecution submissions. You can find that in ours. These are people who have lied for money, and they admitted so on the stand. And of course, it wouldn't be our words to say that Mr. Kokate obstructed justice in the past. This is court's precedent. It happened in the Bemba case, as counsel explained. Your Honors, what this scheme has done is taint the accounts of those witnesses. There's too much doubt cast over their credibility and reliability. And all these factors need to be assessed in light of those findings, as well as their behavior on the stand. Because their behavior was telling. Their testimonies were scripted, they were unnatural, and they were lacking the authenticity that genuine testimony has. No trial chamber can base its conclusions, can rely on such accounts, and expect to secure a just outcome. Your Honors, it is now up to this court, it is now up to your chamber to ensure that this trial is not misused as a tool to serve political agendas. Justice demands that the focus remains on uncovering the truth, not on convicting an innocent man on the basis of false and fabricated testimonies. International criminal justice owes it to Mr. Ngaisona, the victims, and the Central African Republic as a whole to determine what happened. Because justice, Your Honors, cannot be tainted by deception and manipulation. Thank you, and with that, I would like to give the floor to counsel.
Thank you, Ms. Eleftheriou. Mr. Knops.
Mr. President, Your Honors, I will now go into the third topic, the alleged contribution of Mr. Ngaisona to the commission of any alleged crimes, and then mainly, of course, in response to the prosecution brief. Mr. President, if you, after today, go back to your chambers to deliberate on this case, you can ask yourselves in my submissions that 10 years after the start of the investigations in this case, having heard close to 100 witnesses in court, were the following questions for this chamber answered in the affirmative or the negative beyond reasonable doubt. First question, did the court hear any concrete hate speech of Mr. Ngaisona? Second, did the court hear any witness saying that he received an order from Mr. Ngaisona to attack the Seleka or civilians? 3, did the court hear any witness who saw Mr. Ngaisona on the field, physically there, mobilizing alleged elements? from whatever organization. Fourth, did the court see any evidence that Mr. ssona was in touch or liaising with Mr. Francois Bozizé once he left Bozizé, Cameroon in May 2013? Did the court see in this regard any CDR reflecting a phone call between Francois Bozizé and Monsieur ssona before Bozizé left Cameroon or after in May 2013? Sixth, did the court see any forensic evidence, any paper trail of Mr. Gassona's alleged financial assistance to the anti-Balaka from Cameroon? Seventh, did the chamber see any forensic evidence presented in this court that Mr. ssona was involved in the purchase or providence of weapons, ammunition, or turayas? Eight, and even if your honors were to find that the prosecution was able to demonstrate a positive answer to those 7 questions, did the court hear sufficient evidence of this, where, to the extent that there was a tangible link to the commission of actual crimes on the ground, even if one would accept those acts perpetrated by Mr. ssona in this hypothesis? Where was and is the tangible link between those alleged acts and the crimes on the ground? Mr. President, this 8th question, you will not arrive in our submissions to answering this, because the first 7 questions can only, in our submissions, be answered in the negative. There's no other conclusion after this trial that those 7 questions cannot be answered in the affirmative, that there is evidence to this extent. Now let us have a closer look at the prosecution evidence when it concerns the alleged contribution of Mr. ssona. The prosecution full well was aware, Mr. President, that to prove the alleged existence of an organizational policy which should collectively mobilize the youth and other organizations against the Muslim population, it needed to frame, in this theory, it needed to frame Mr. Gassona's speeches into hate speeches. The whole organizational policy is premised upon this fiction. In order to do so, Mr. President, the prosecution had only one choice. It had to twist the public speeches of Mr. Gassona such that it would fit its narrative. However, we have an intelligence chamber before us, and words speak for themselves. If you honest look simply at the words uttered by Mr. Gassona, like the speech we just showed on the 6th January 2013, it all speaks for themselves. They do not demonstrate in any way any plan, pattern, or coordinated collective mobilization against the Muslim population. The prosecution had to endorse its theory, had to entirely ignore the consistent appeals for peace and dialogue which Mr. Gassona constantly promoted throughout his speeches. His even categorical rejection of violence, many calls to the anti-Balaka to lay down their weapons. The speech in which, in June 2014, he even asked respect for the holiest day of the Muslim population, the Ramadan, to respect that day for his Muslim brothers. In a desperate attempt, Mr. President, to fill the gaps in its narrative, the prosecution could only resort to speeches made by others, like Zama or Yambete, and try to attribute this to Mr. Ngai, to no avail. Paras 30-31 of this brief. The prosecution case dramatically collapsed already on this part. Then they needed a second string for the theory, the Kokora mobilization. They had to tie Mr. Ngai to Kokora in order to uphold this theory. But it did not anticipate, the prosecution, that its case would also dramatically collapse during this trial with regard to Kokora and Kowak. We have all seen and heard it throughout the 4 years of this trial. The prosecution has, throughout this trial, not achieved to present to this court one tangible piece of evidence support the alleged involvement of Mr. Ngai in such elusive movements. The allegations rely almost exclusively, Mr. President, on anonymous hearsay, such as an unsupported UN report and the hearsay evidence of P2625, prosecution brief para 3638. And also in its closing brief, the prosecution had to rely on P0287 to argue, to have the judges believe that ssona used Kokora to marshal the youth. That's the words in para 41 of the brief of the prosecution. This depiction of the evidence, Mr. President, is only quite selective. First, in his prior recorded statement, this witness clearly said that Mr. Ngai could have been instrumental in mobilizing the anti-Balaka later on. And secondly, during the defense cross-examination of this individual, P0287, it turned out that his conclusion, his assumption, was merely based on assumptions without any support. Exit Kokora. Cameroon. That's what the prosecution needed as well to fit its narrative. But also here, it did not anticipate that the Cameroon theory dramatically collapsed during the prosecution and defense case. It dramatically collapsed regarding the so-called criminal policy to have Mr. Bozizé return to power. There is no probative evidence in relation to this so-called inner circle in Cameroon and the ensuing meetings there. We give you 8 examples to illustrate how and why the prosecution case dramatically collapsed during this trial on Cameroon. First, as highlighted in our defense brief, the undefined and constantly evolving nature of the so-called inner circle has been an instrument by the prosecution in a rather arbitrary manner and since the very outset of the case. It was like what the French say, a chameleon. How so? You saw, Mr. President, new members conveniently made their way into the so-called inner circle to fit the prosecution narrative. For instance, Webio, Buragora Gallo, and Nangaba, prosecution brief 224-225, became suddenly at the 11th hour of this trial members of this inner circle. Prosecution never mentioned them. Yet at the 11th hour of this trial, it was their desperate attempt for the existence of a criminal policy. Prosecution seems to pursue the strategy that if individuals are having conversations on Facebook, showing some type of knowledge, alleged knowledge of certain texts, or even conflated Muslims with Seleka, these people are simply part of the inner circle. Just put them there, park them there, and it's all fine. An artificial construction to persuade the court that there was an inner circle, which theory would strengthen the so-called shared criminal intent. Judge Henderson, in its mentioned Blé judgment, para 91, called such an approach a everything proves everything approach. I think that word is justified to use it here, Mr. President. By saying that, Judge Henderson said that such an approach assumes guilt by association without concrete evidence of a deliberate and coordinated criminal policy. Prosecution failed to demonstrate that any of these people conceived, developed, or implemented a criminal policy against the Muslims and alongside Mr. Bozizé. WBO, as you all have seen, he was one of the witnesses best placed when it concerns Cameroon at this trial. There was no better witness for this court than WBO. He was the one closest to Bozizé. Prosecution didn't produce any such a direct witness as WBO. WBO testified before this chamber very convincingly, and unambiguously he refuted any involvement in any form of resistance. In our submission, Court of Law should not adopt such a everything proves everything approach as the prosecution has put forward in this case. The second remark about why the case of Cameroon collapsed for the prosecution. Aside from the alleged Hilton meetings, which were already extensively addressed in our brief, it dramatically failed to establish the prosecution that Mr. ssona had a coordinating role. The prosecution attached considerable weight to one single email from Pastor Cherry Bongolo to Levi Yakite on the 10th of May 2013. That's paragraph 58 of the prosecution brief. It claims that Mr. ssona was coordinating from the outset. It should be deduced from this email. Yet, Mr. President, the court can find no evidence on who this Mr. Bongolo was or any connection he might have had with Mr. Bozizé or the so-called inner circle. There is simply no evidence. There is no evidence that any meeting in Cameroon involving Mr. ssona was allegedly there with Bongolo and others. No witness ever mentioned Mr. Bongolo, nor his presence in any meeting in Cameroon, let alone in the week of the 13th of May, when Mr. ssona, by the way, was clearly in Paris, as the evidence has demonstrated during this trial. Moreover, in this very email, Bongolo alludes to spiritual matters and an upcoming demonstration in March, referring at a diplomatic or peaceful strategy. In the third place, speaking about Cameroon, the prosecution blatantly distorts the evidence when asserting that WBO confirmed Marias Faimounouazoui, Eric Damboy, François Bozizé, and Franklin Bozizé having visited Mr. ssona at the Gulf, para 126 of the prosecution brief. Yet, Mr. President, again, WBO, the witness most placed to Bozizé, directly placed to Bozizé, gave direct testimony that while these individuals visited the Gulf, they did do so separately and were clearly there just to see the president, not Mr. ssona. Webby also highlighted during his testimony that these people were either visiting either Bosse's family members or members of the church community of Bosese, like Yvon Sanguet. So therefore, far from suggesting any criminal intent, this evidence simply reflects usual interactions one would expect amongst relatives. Fourth, another claim lacking any evidence is the assertion that on the 29th August 2013, Mr. Ssona, Bosese, Yakete, Kokate, François Bosese and others met in Yaoundé while Bosese explicitly called upon them to regain power. Para 114 prosecution brief. Yet the evidence clearly demonstrates, Mr. President, that Bosese was not in Cameroon on that date. Facebook messages in question merely mention the potential presence of certain individuals in Yaoundé, without any reference to Bosese's presence or any meetings taking place there. The prosecution has never demonstrated throughout this trial the existence of a link between Bouragora, the alleged author of these messages, and Bosese, or his so-called inner circle. But in order to prevent its case from collapsing, the prosecution had to resort to non-live testimony evidence, had to resort to prior recorded statements or low probative evidence, press articles, while neglecting corresponding court transcripts and more direct evidence which contradicted their claims. Few examples I give you here. The OTP relies on P992, the statement he gave, the prior recorded statement, paragraph 32, to argue that meetings involving Mr. Ssona and Bosese associates took place in Cameroon, paragraph 54 of the prosecution brief. However, when this evidence was tested in this court, P992 clarified that he only heard about these people in Cameroon, but didn't know what it was about, whether it was to reinstate Bosese or something else entirely. 992 testified that most were military, unlike Penn, who he described, Mr. President, before this court, as un brave civil, une brave civil, and only took care of the children after they arrived in Bangui. Evidence which was totally overlooked by the prosecution. In the OTP brief, para 110 footnote 209, the OTP conveniently only relies on the prior recorded statement of witness 0291, while again entirely ignoring his live evidence. Live evidence where it became clear that this evidence given by 0291 number of references to create this impression, this false impression. However, when the court would exercise an item-by-item review, it would detect that individuals from these respective groups, dus the KNK, FACA, Anti-Balaka, never met Mr. Ngai together. At most, the evidence might suggest that Mr. Ngai met with some of them individually. It's a totally different story. As to the claim of 2673, that Colonel Namboya and Steve Yambete met Mr. Ngai and Bernamo Kom in Yaoundé, it was merely based, as it turned out during this trial, on hearsay and any lack of cooperation. More importantly, there is no evidence indicating that these alleged meetings aimed at organizing the Anti-Balaka as such. Many witnesses mention simply courtesy meetings or visits or coincidental encounters in Cameroon, often not even involving or mentioning Mr. Ngai. In the seventh place, why did the case collapse of Cameroon? The prosecution was only able to cite P1719 regarding Sabe Willebona, Rockamokom, or Yambete's liaison role with the so-called Yaoundé authorities. Also here, the prosecution overlooks the direct and contradictory evidence of D30-4914 and WBO, two direct witnesses who were there on these very aspects. Remarkably, the prosecution did not try to rebut this evidence. It did not challenge this evidence, not even during the cross-examination. They didn't file a rebuttal request to rebut this strong evidence. Direct evidence of witnesses who were there. There was none of the prosecution witnesses who were in this position as these two defense witnesses. It was unique testimony before this court. They were the real insiders of this court in this trial. They were the real insiders without any motivation, with any incentive to give false testimony. It is symptomatic of the prosecution tendency to simply ignore this evidence, this strong evidence that fully contradicts its theory. And lastly, about Cameroon, Mr. President, the prosecution claimed that Mr. Ngai organized a meeting around the third week of November in Yaoundé, where he supposedly received instructions from Bozizé regarding the 5 December attacks. That's in the OTP brief 201 paragraph, is entirely, as the court will see, unsupported. It's also misleading, once more, when it claimed that P0801 would corroborate the existence of such a meeting with ssona and Ngai at the end of November. However, have a close look at the statement of 801. He never mentioned Ngai among the participants to a meeting at the end of November. Transcript T35, page 8, lines 6 till 7. And lastly, Your Honors, the prosecution claims Eugène Ngai had a role in the 5 December attacks. You can see that he was included amongst the FACA in Bangui in a slide displayed by the prosecution last Monday, it was slide 36. Yet also here the court will observe that this allegation is entirely unsupported as demonstrated in our brief.
I think it might be a time to break now if you have a...
Yes, because after the break I need maybe 30 minutes to finish this presentation.
However, we can resolve orally a short request by Ms. Dimitri. You've requested to correct the transcript. This would be a correction of content. We cannot do that. However, we have a hearing today and you can simply put on the record what you wanted to be corrected now. Just one phrase, I think it is. Yes?
Thank you, Mr. President. Indeed, I didn't want to interrupt the hearing, but when I mentioned P2475 yesterday, and this can be found at page 114, line 4 and 6 of the English real-time transcript. I said it twice I meant P2476. Thank you.
Thank you. So we have now the break until 11:30.
All rise, veuillez vous lever.